and I want to start with the Skitzki sentence.
Yeah.
With so much at stake in delivering that sentence, what was going through your mind?
Well, first of all, I can't get into too much detail about the trial itself, but I'm happy to talk about the surrounding circumstances. I'll talk about Skitzki insofar as it was what I think characterized before as a bit of a metaphor for all of the horrors and the phenomena that was touched upon in the missing, murdered Indigenous women and girls inquiry. So it was clearly the focus of many people. We were dealing obviously first and foremost with a criminal trial, and I'll get to the sentencing in a second, that needed to provide for the accused person due process. That's the first and foremost obligation and rule of a judge and a jury and all court participants. So we did that, and hopefully we did it successfully. But also, a trial doesn't have to just be fair. It has to be fair, but it also has to be respectful. Fair and respectful both to the accused person, but also to family, to friends, and to the broader community. Now, who's the community in this instance? Well, it's obviously the Indigenous community who were highly and acutely engaged, but so too was it the broader Manitoba community who was, I think, deeply, profoundly affected by this case. So when it came to the sentencing, there was obviously a need, in my view, and the need of all the participants, including the Crown and including Defense Counsel. I want to give Defense Counsel their due as well. They were very willing to collaborate with all the court participants to ensure that the process of the sentencing, like the process of the trial itself, was validated or legitimated in a way that made the broader public, including the Indigenous community, feel, perhaps for the first time in a long time, that we were trying to integrate, absorb some of the Indigenous legal practices, traditions, and symbols that had meaning for them. So what was going through my mind wasn't simply the act of imposing what I had to do as the sentence, which was largely predetermined by law, but it was also to legitimate a process for the broader public that needs to trust our system. And I was thinking a lot about that, as I know both parties, the accused and the Crown was.
So I want to ask you more about that balance, because obviously in that case, many in the Indigenous community and in Manitoba overall, thank you for your language, for your message, in how you handled the sentence, the words you chose. Now on the other side of things, and there was the acquittal of Robert Jeffrey Morton this year in the death of Headingley and William Walter Amo. Now following that, the now late AMC chief Kathy Merrick called this, quote, a gross miscarriage of justice that perpetuates systemic racism and, quote, contravenes the basic principles of our basic human rights, safety, justice, and equity for First Nations people under the law. How do you achieve the goals of reconciliation in the justice system, as you were just talking about, which is supposed to be impartial? How do you do both things in a province where you see the community reacting and leaning in on every verdict in such a way?
Well, I had nothing but profound respect for Grand Chief Merrick, but I don't want to talk about her characterization or her assessment of that case. That would be inappropriate for me to do. So I don't want my answer and my silence about that case to be seen in any way as an endorsement of that view. The system itself is flawed, and we're going to make mistakes. And I've recently presided in cases where miscarriages of justice were identified, appropriate apologies and comments were made. But those were cases that were identified as that. We have to be careful, and I'm not suggesting Grand Chief Merrick was anything but careful, because she was a passionate and deeply engaged woman. But we have to be careful about not simply taking a verdict that we're not happy with and dissecting it as necessarily a miscarriage of justice. Such cases exist, such cases will continue to exist, hopefully minimally, and we can chat about that if you want. But if we're talking about more broadly speaking, and I think this is what I take your question to be about, because this is really what I think it should be about, insofar as my capacity to answer it, is about systemic trust. What do we do to gain the trust of Indigenous leaders?
And keep the trust.
Yes.
Because of course what we're talking about here is if there is sort of a
push-pull.
A push-pull at every verdict.
Yes.
How do we overall maintain that trust throughout?
Well, the push-pull is always going to exist, because we do have a responsibility in our system of justice to ensure that accused persons, if we're talking about the criminal realm, but we can talk about any area of realm, to provide a fair trial. And what is a fair trial? It means ensuring that due process is properly afforded to everybody. But I like the phrase fair and respectful trial, because fair and respectful doesn't just involve something being fair and respectful to the accused, but it has to, obviously, but it also involves a degree of respect and what I'll call this new phenomenon, this trauma-informed approach for victims and families and for the broader community. If we can do that and go beyond a simple assessment about the verdict or the result, I think we will be doing our job to legitimate the process that we offer up. But I think it takes more than that. I don't want a situation, Marcy, where our level of trust as it's being assessed by any one community is dependent upon the result in a given case. Otherwise, we're effectively no better and no worse than what we're doing to obtain or not obtain the approval of a given community.
So if not that, what do you need to change in the system to achieve that level of trust?
Well, we have to ensure the process is credible, that the process is something that communities, including the Indigenous community, can endorse. They have to feel, to the extent in the criminal realm, for example, because we could get into some of the areas that they're now themselves going to be, I think, adjudicating and taking control over. But if we're talking about the criminal realm, to the extent that we're dealing with perhaps a disproportionate number of Indigenous participants, we have to make them feel like they're part of it, that we're engaging with them and we're incorporating, integrating, and otherwise understanding legal traditions. So Skitzki is an example of what, and we have to be humble about it, what we attempted to do, but we want to normalize that. So back to your original question, what can we do? Well, we as an institution can, and I think have done a great deal. It's not enough, but we're starting. We have in the Court of King's Bench a committee called the Trust, Reconciliation and Access to Justice Committee, TRAC for short. I announced this, I think, in 2017 at the call to the bar. One of the first courts in the country to do this, and it really does act upon the calls to action of then Senator Murray Sinclair. It's based on 4 pillars. The first pillar speaks to the very issue that you're, I think, getting at, the question of trust. We do outreach, not the type of outreach we would typically do with schools or the grand public in terms of explaining people how we do what we do, why we do it, and we're instead there to listen. We're not there to kind of pontificate about how good we are, how magical our system is. We're there to listen to Indigenous Manitobans and hear what they have to say about the justice system.